Good day, ladies and gentlemen. Today, I wish to talk about the new compounding rules under FEMA. Soon after the Foreign Exchange Management Act 1999, FEMA, was passed by Parliament, the Government of India issued a raft of rules and the Reserve Bank of India, RBI, issued a raft of regulations for implementing the new legislation. One of these was the Foreign Exchange Compounding Proceedings Rules 2000, issued by notification number GSR 383E, dated the 3rd of May 2000. Since then, till September of 2024, all compounding proceedings under FEMA were carried out in light of these rules. To give you a little bit of background, unlike the taxation enactments, FEMA has a single omnibus penalty provision in section 13, which says that any contravention of any provision of the Act, regulation, direction may attract a penalty of anything up to 300% of the amount involved in the contravention. This, you will realize, is a very severe penalty provision all by itself. Therefore, in order to mitigate the rigor of this penalty provision, in the case of reporting contraventions or even non-reporting contraventions in legal transactions, which are not in the nature of any serious offense, the legislature wanted to grant some relief to mitigate the rigor of the penalty provision. That is why they introduced section 15(1) in FEMA, which enables contraventions to be compounded mostly by the Reserve Bank of India, except that contravention of section 3A would be compounded only by the Enforcement Directorate. And section 15(2) offers protection from re-agitating any contravention that has been compounded in any subsequent proceeding. On the 12th of September 2024, Government of India issued the new Foreign Exchange Compounding Proceedings Rules 2024, wide notification number GSR 566E, dated the 12th of September 2024. Further to this, the Reserve Bank of India issued APDIR Series Circular number 17, dated the 1st of October 2024, in order to familiarize the stakeholders with the new rules and to issue directions to the authorized persons in respect of the new rules. For your benefit, I wish to quickly survey the changes brought about by the new compounding rules compared to the old rules of 2000. To begin with, the delegated powers for compounding for various officials of the Reserve Bank of India have been substantially revised upward. For the Assistant General Manager, the limit has gone from 10 lakhs to 60 lakhs of amount involved in contravention, which he is empowered to compound. Similarly, for the Deputy General Manager, it has gone from 40 lakhs to 2.5 crores. For the General Manager of the Foreign Exchange Department, it has been increased from rupees 1 crore to 5 crores. And any compounding where the amount involved in the contravention is over 5 crores, it will hereafter be handled by the Chief General Manager. The previous limit for the Chief General Manager was over 1 crore. So these are the changes in the delegated powers. But the new rules have not affected any changes in the delegated powers of the Enforcement Directorate officials for compounding under Section 3A. Those limits remain the same as in the 2000 rules. Therefore, I am not going into the details. Secondly, the question of mode of filing of a compounding application under the new rules. Here it is pertinent to point out that a few months ago, the RBI set up what is called Platform for Regulatory Application, Validation and Authorization, PRAVAH for short. The purpose of the portal is to enable stakeholders residing abroad, like NRIs, PIOs, OCA card holders, and foreign investors, to make applications to RBI online for various permissions which they may be required to obtain from RBI. This portal also accepts compounding applications. However, the help desk at the PRAVAH portal gives you the telephonic information that hereafter compounding applications can be filed only at the PRAVAH portal and not physically at the compounding desks of any office of RBI. This information is not correct because the APDR series circular number 17 of 1st of October at para 3.1 specifically says that a compounding application may be filed either physically or at the PRAVAH portal. At a practical level, this means a lot of relief to several companies because every compounding application is required to be accompanied by not only the memorandum and articles of association but by the audited balance sheet for every year since incorporation. For companies which have been around for many years, this is quite voluminous and it's always a challenge to scan, compress and upload all these documents at PRAVAH portal. It may be easier to just file hard copies in the office of the RBI. So this is a welcome option which has been offered in the new rules to file either physically or online. The next point is the compounding application fee. All these years used to be rupees 5,000. That has been enhanced to rupees 10,000 plus GST at the rate of 18%. Next, previously you could pay the compounding application fee as well as the compounding charges levied in a compounding order only by a demand draft. Hereafter, you have the option of making those payments by electronic means such as NEFT or RTGS as well. The prerequisites for filing a compounding application remain broadly the same as they were under the 2000 rules. First of all, the contravention has to be quantifiable in order to be compounded. Secondly, no compounding should have been done within the previous 3 years for the same or similar contravention. Otherwise, this contravention is not eligible for compounding. Thirdly, compounding facility is available only for non-serious contraventions, not for serious offences like money laundering or terror financing or the like, or any transaction which endangers the sovereignty and integrity of the country. Such offences are not compoundable. Next condition is that an adjudication order should not already have been passed by an enforcement authority. Only then a compounding application will be entertained. And finally, procedurally, a very important point is that administrative actions should have been completed before you file a compounding application. What are administrative actions? Wherever there is a reporting contravention, for example, you have failed to file an FCGPR return, you have failed to refund share application money received within the time permitted, or you have failed to make an allotment within the time allowed. These are all procedural contraventions which can be addressed. Whichever contravention can be addressed by a filing, that filing should be done with late submission fee if it is applicable. For example, FCGPR return or any other return, Form FC for overseas investment or Form ECB2 for external commercial borrowing. These returns should be filed up to date before RBI will entertain an application, a compounding application from you. If you have failed to refund share application money within time, you will have to seek RBI permission to either make a belated allotment or make a belated refund. You will have to get that permission and carry out the direction of RBI, report it to RBI before you can file a compounding application. There may be other contraventions of a non-reporting nature where you may have to seek condonation or ex post facto approval of RBI. Only thereafter a compounding application will be entertained. This is what is meant when the rules say that all administrative actions should be completed before filing an application. Now we come to the cases where compounding is not possible. That is drawn partly from the previous list of prerequisites. For example, if it is non-quantifiable, it cannot be compounded. If it is a serious offense, it cannot be compounded. And then, if compounding is done now, then for the next 3 years, any contravention that you do will not be compoundable. And one other condition is that penalty order should not already have been passed. If it has already been passed, then you don't get the chance to compound. Finally, cases to which Section 37A applies. This is important. Section 37A empowers the enforcement authorities to attach properties or assets in India of a person who is holding properties or assets abroad in violation of Section 4 of FEMA. So if it is a case to which Section 37A applies, you don't get to file a compounding application for that contravention. Finally, under the old rules, if an appeal was pending under Section 17 or Section 19, you could not have filed a compounding application. That restriction has been done away with in the new rules. Even if an appeal is pending under Section 17 or Section 19, you can still file a compounding application. These are broadly the changes brought about by the new compounding rules. I hope this information will be useful to you. I look forward to sharing more information and thoughts on FEMA from time to time. Thank you.